for correction, my finding. I will permit to make for an inclusion in the research hearing.
Has happened.
But only number has been wrongly typed. Tomorrow.
Is the inclusion.
My lords, item number 24. In fact, I'm coming from outside. It may please be fixed at 2 p.m. if it is possible.
See.
Yes, your lordship. If it's come in order, it's okay.
Item number 1. Yes.
Lordship, 4R. I have already explained before your lordships that on first occasion, my lord, the whether I placed before the honorable tribunal regarding this on the question of law that for withholding gratuity or pensionary benefits that the office government servant should be at least in discharge of the official duty, not unrelated with the official duty. And that has been clearly explained in my lord in para 4R of the way, and reply in the reply it has not been made clear what prompted them to take different stand. And I have also annexed the copy of the tribunal's order in respect of the on self-same cause in respect of the co-accused also.
Side of DS Nagara's case. What is the WS? I want to see the WS filed by the respondent. Where is the WS?
In reply, my lord,
They reply before the.
reply before the honorable tribunal.
This is a very clear reply, which means
Tribunal is already recorded this judgment. At page 175, my lord. Is their reply. Nine.
59.
In reply before the respondent, my lord, respondent submission at page 140 with reference to 4R. Holding there. Para 25.
Paragraph.
Paragraph 5. Second paragraph. The exact portion of the practice could order paragraph 7.
7. So that is the judgment of the apex court. It is your stand recorded.
My judgment.
Your stand before the tribunal. What was your stand before the tribunal? Where is the WS? Written statement or reply, whatever you call it.
Reply there.
Tribunal is ordered. একদম শেষে টাকা এটা না
Page 158.
এটা না এটা না এটা না ভাই গো, এটাও না হুম 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 ওগুলালটা তুমি ই করো ওগুলাল দিয়ে দিয়েছো দুটো আমারটা পেনশন রুল লর্ডশিপ আর একটা ডিবি আছে চারটে আর একটা ডিবি জয়পুর বেঞ্চ চারটে আছে ready? অ্যাপিয়ারেন্সটা দিয়ে দাও। Here, what? এইখানটা একটা মারুন আর এইখানটা একটা মারুন। That is the old rules, my lord. Rule 69, and it has been recast in 2021 as Rule 8. That is 69.3. Same, my lord. It has been recast. In fact, my lord, Rule 9.4, from Rule 9.4, Rule 69 emerges. Because the functions to be adopted, my lord, it is in 69, operative part. 69 is the law. Rule 9 is the law. Rule 9.4. It has been mentioned there.
Reply filed before the tribunal. See, they have stated on page 133. Paragraph 25. There are business criminal cases pending against C so and so. 3 cases have been given: Sankrali PS case, personal loan matter, and Bartola PS case.
All personal loans and banking related.
They are not on that. After that, it refers to Rule 8.3 in the next paragraph at page 130. Rule 8.3 of the CCS pension rules. Then it says that in the case of government servant who is retiring on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceedings are instituted.
That was in the Rule 69 also, my lord. Rule 69.3. Text has not been changed, my lord. Only recast in the one. It has been put in one basket. Rule 9 and Rule 69. Text is same. Rule 9.4, 8.3, and Rule 69 1A, Rule 4A.
Rule 69 1A.
Hmm.
8.3 is similar to which provision or identical to which?
And 69 1C.
1C. It is not. It is not in the same language.
No gratuity shall be paid to the government servant until the conclusion of the departmental or judicial proceeding and issue of final orders thereon.
Please try to understand what we are saying. We have just now pointed out he has reproduced Rule 8.3. Which provision in 69 is in the same terms?
9.4, my lord.
9.4. You are saying 83 is similar to 69. That is why the confusion. Yes, 9.4. Rule 8, we want to see the entire provision, Rule 8. The present Rule 8 under the 2021.
Present rule 8, my lord, rule 8.1 is equivalent to rule 9.1.
Have it.
Yes, my lord.
This is the latest one.
Latest one, my lord. Side by side, I have noted, my lord. देखने पड़े तो वही दिए दिया
Where's the judgment? Nakara's judgment.
Nakara's judgment, Lordship had asked me to produce the division bench order of the Honorable High Court, Delhi. That I am getting ready. Where Nakara's judgment has been also quoted there. तो এটা আছে না, Nakara's judgment.
Referring to OP NASA. OP NASA.
Lordship OP Nasa.
Not
But-
required.
Not record. I am giving, my lord, a very much relevant, my lord. This is division bench judgment. It arises out of, my lord, the principal bench order which has been quoted here. And department contested and it has been dismissed. Repetition. এটা আপনাকে একটা দিচ্ছি আমি দাঁড়ান। প্রভুলাল আরেকটা প্রভুলাল আছে না Nakara's text, my lord, has been quoted at page 113. ছিল নাকারার জাজমেন্ট নাকারার জাজমেন্ট ছিল এখানে পুরোনো ফাইল থাকো
One of the judgments that you are handing us is dealing with the provision which is calling for consideration in this case. Why are you giving such judgments which are dealing with other provisions, Bihar pension rule and this and that? Why?
That is on rule 9 and 691B, my lord.
Which judgment?
That I have given.
Which one? Tell us. You have
That is
given us-
Prabhulal.
Huh?
Prabhulal. That is Honorable Delhi High Court judgment. my lord.
Prabhulal.
Hmm. It arises out of, my lord, principal bench order, which has been quoted.
Judgment is of 2010. The amended provision has come into force in 21.
Same provision is there, my lord. Same provision is there, my lord. It has been quoted here, my lord. It is principal bench order that has been quoted in the order annexed to the this petition, my lord. Arising out of that order.
So you don't want to rely on the judgment dealing with the provision. You want us to rely by inference that it is the same. Now we should sit and tally that every word is the same, then we should rely upon it.
Lordship, rule 9 and 69 is recast in rule 8 in the verbatim, my lord.
So in which judgment this court has said that it is in the same terms?
Same terms.
We'll have to sit and why can't you get a judgment dealing with this provision? In the last 5 years, there is no such judgment. 4 years.
It is
You are relying on old judgments dealing with the earlier provision prior to the new coming into force of the new pension rules.
the new
You are
pension.
relying on judgment of
Still,
Bihar pension.
it has been referred in case of provisional pension. They had mentioned rule 691B. Still, it is in force, my lord. They are referring, my lord, in case of their order for provisional assessment, the pension, they had referred to rule 691B. It is very current. Page 78.
Can you please understand what we are trying to say?
Lordship, I can follow.
You cannot follow, then we cannot help you. On the last occasion also the same thing happened. Now I remember. You are relying on judgments dealing with the unamended provision and the earlier provision or Bihar pension rules. Why should we rely on those judgments?
The judgment, my lord, the maxim is very.
Maxim applies to facts and law. Whether the law is same, in the same terms, in the same words, how do we know? We should sit and tally the two provisions word by word that they are same.
It is now, my lord, it is still that old rules are referred.
Maybe you are knowing much more than us. We understand that. But we also, before we pass a judgment, we have to know also. And you refuse to show a judgment that day also, today also, it is the same position. The same old judgments you had come with on that day.
No, Lordship, Prabhulal judgment is not.
Dealing with 2021 pension rules. Again, you say that it is the same, only the number has changed.
Current judgments are, it is still.
Very difficult, I know. We know it is
Current-
difficult, but it's not impossible. And that is what you are here for. And that is why it
Lordship,
was
give me another chance. I'll search out whether rule 2021 rules that order has been passed in other courts.
No, now leave it. We have asked for the book, we'll do it. We have understood how much you can assist. Every day it has to be adjourned for the same thing.
Lordship, I will search again.
We don't know
It is
because
not-
this was the same situation.
Same situation, my lord.
2 dates prior to today, it was the same situation. This is how we were grappling on that day also. Today also, there is no change. The least said is very unfortunate. All you were required to do is to show.
No,
You
old,
don't even have the two provisions that you can comparatively read.
that's why
Everything we have to do.
I have given, my lord,
For
because
you to do.
because in the orders passed, the old rules have been referred. I have gone to for old rules.
The order has been passed relying on the old rules.
They have referred, my lord, provisional page 78, my lord.
The WS come to their reply filed before the tribunal.
Now, in the reply, they have sent a rule 8 3 and 4.
Like we have stated
In reply.
on the floor,
But order is same.
Where is the order? Where is the order? Order is prior to 21.
Page 78, my lord. Provisional, he has been retired very recently.
'71.
Page 78.
8.
8.
This is order of 23. It is relying on rule 69. 69 has to be read with rule 9 or rule 8
Rule 9.
in 23
Yes, my lord.
after
In
the amendment.
69, there is no provision in the 69 in pension rules 2021. Rule 9 and 69, my lord, put in the same rule under rule 8 for reconstruction. Certain rules have been just reconstructed.
Sixty-nine one B has been referred in this order.
Yes, my lord.
69 one
That is old pension rules.
What is the new pension rule corresponding to 69 one B?
That is there, my lord, in the new
Which one
rule 8.
is akin to 69 1?
Yes, everything is there in the rule 8. My lord, I may be permitted to have a look in the rule 8.
Please read 69 and rule 8, that it is in the same terms. Please read. Now first read rule 8 of the new rules. What does it say? Please read the opening line of rule 8.
The president reserves to himself the right of withholding a pension or gratuity or both, either in full or in part, or withdrawing a pension in full or in part, whether permanently or for a specified period, and of order recovering from a pension or gratuity of the whole or part of any pecuniary loss caused to the government, if in any departmental or judicial proceedings the pensioner is found guilty of grave misconduct or negligence during the period of service, including service rendered under re-employment after retirement, provided that Union Public Service Commission shall be consulted before any final orders are passed. Provided further
Now
that
read 69. It is the same.
it is Rule 9(1), my lord.
What are you saying? Just
Rule
now you
8.
said 69 is same as 8.
69(1)(b), my lord. It has been recast as Rule 8(4)(b).
Just now you said rule 9. Now you are saying 8.4b.
Lordship,
Just
two
now you
rules,
said
two
rule 9.
separate set of rules have been combined in one rule. That is rule 8. Every provisions of rule 69 and rule 69 has to be read with rule 9.4. That is in the old rule. It has been now in the same rule. Text is same.
According to you, 69 and now has been merged and 8 has been.
8, rule 9 and 69, both in 8. It was difficult because it was, rule 69 was otherwise separately scripted. That's why it has been merged with the rule 9 to form rule 8.
Parties have been heard. Get us the.
No further hearing.
Item number 2.
इसमें क्या है मिलेगी in this matter, I am happy on behalf of the petitioner. Last occasion, your lordship has been pleased to say that all the application will be taken up. I pay only 1 day's time because all application I have not find out. I pay only on 1 day today. Application for restitution and application for other application. Last occasion, Canfor is a restitution application. Pardon?
4 is listed today.
Yes, it is a restitution application.
Yes.
I will state a paragraph 2 of my application. My learned fees is happy on behalf.
On behalf of the state respondents.
What is it?
Paragraph 2, madam, page 4.
Yes. Take down. There's an application
Get 1 week.
13 তারিখে আসছে।
আমি এখন রেকর্ডই আছি। Get.
Item number 3,
দাদা কবে আছে?
The notary gets to appear on behalf of the petitioner. This writ application has been filed by the state government against the order passed for the learned tribunal. Well, may I tell you also very short cut. 2006. My lord, 2% filed an original application under the rules framed by the central government jointly, because under their contentious rule 5A, if there is a common cause of action. বান্ডিল অফ জাজমেন্টটা কোথায় দিয়ে গেছিল ডিপার্টমেন্ট সেটা কোথায় যাতে করে দিতে পারো
yes,
দেন মালার
that is the impugned order.
মানে কাইন্ডলি at page on the last page for the document 8th December 2022. আরে এটা কোথায় বান্ডিল অফ বাঞ্চটা দিয়ে গেল এটা কোথায় ডিপার্টমেন্ট But I'm not placing the first paragraph. Applicant is a great leader praying for setting aside the impugned order of the respondent appearing at page 36. Earlier, the tribunal in the matter directed authority to grant device care to all the leaders pursuant to the that applicant has moved this tribunal is being similarly cause circumstance. আরে বাঞ্জিল বাঞ্চটা এতক্ষণ ধরে নিয়ে আসছিলাম কেন
কোথায় গেল কেউ তো বসেছিল হঠাৎ করে বেরিয়ে চলে গেল
May I proceed? যাও, এতক্ষণ ধরে কি করছিলে
ওটা না দেখালে তো
ভালো হবে পাটনা হাই করে জাজমেন্ট সব জাজমেন্ট
ঠিক আছে
না দেখালে তো টাইম লাগবে Now kindly see page 85 for a moment.
Right.
85, 85. Order dated 30th August 2022.
Which order?
Murad,
Which order?
order dated 30th August 2022.
Of these proceedings.
Yes, of this proceedings. ডিপার্টমেন্ট থেকে দিয়ে গেল হ্যাঁ আমি তো বসে আছি এখানে
30th August of
30th August 2022. Why is, in 2011, the applicant number 1 died, then application for substitution of filed with an application for setting his amendment about 11 years, 8 months. When they are facing the difficulty to substitute the name, then they withdraw the application.
The first order is of 11/12/23 in this proceeding. You are referring to order of 30th August of the tribunal.
Yes.
You said this proceeding.
Oh, no. Sorry, madam.
Tribunal.
Kindly excuse me, madam. 85. Page 85.
Page 85.
কি করে আমার বাবা তো কষ্ট করে লাভ কি আছে? আরে একটা কাজ করুন না, পাসপোর্ট এতক্ষণ বলি না কেন? আমি তো জানি না যে ওরা নিয়ে গেছে। আমি যেতে রয়েছে হ্যাঁ
ছিল গতকাল চুরি ছিল আর কোনো আর এই বাড়িতে ছিল আর নেই
তাহলে তোমার অংশ করে নেন, তাহলে বলে দেখি, তখন তো বলে দেখি।
Yes, we have seen it.
Your Lordship got it? That means, my lord, on 30th August 22, but because common cause of action, kindly see the rule framed by the Sun Company. Rule 5A,
Notification dated 94.
21st December 1994. Rule 5 small a. West Bengal Administrative Tribunal Procedure Rules 1994. Yes.
Yes, we have seen it.
That means, my lord, if there is a common cause of action, then, my lord, they can file applications jointly. Then, my lord, if an application is required to be verified, who has verified, my lord, according to kindly see the rules, verification rules at page 19.
Page 90.
Yes, page 19 of this notification.
Yes.
I, such and such, name of the daughter of such and working as journal, verify the contents of paragraph 2 to my knowledge, personally believe that I have not supplied material. That means verification is necessary, just like when order 9, rule 3. Petition was verified by the applicant number 1. There was a common cause of action. If there is a common cause of action, after the day amendment, date of the applicant number 1, whether the tribunal has got any jurisdiction to grant dispose of the applications without file any application for either separately or to recall the order passed by the tribunal, that is on 30th August 2022. First question, Madam.
First applicant has died.
Yes, 2011. Madam, date of death is 8th March 2011. And 30th August 22, application for substitution and for setting aside amendment was dismissed as withdrawn.
Yes. Is the date of death?
Date of date is 8th March 2011.
8/3/11.
8/3/11. কোথায় গেল?
এই যে এখানে রাখলেন
এই judgment গুলো এখনই কোথায় গেল?
আগের দিন ফাইলে নেই, জজের ফাইলে তুলে দেননি।
না না না
আগের দিন জজ
না না এতে দিয়ে গেছে গত রবিবারে।
আপনাকে দিয়ে গেছে।
না তোমাকে বাড়িতে তুমি রিসিভ করো।
রিসিভ করে তো আপনি নিয়েছেন, আমার কথা
না না
রিসিভ করতে বলেছি।
টেবিলে পড়েছিল দেখলাম।
কোথায়?
আমি পড়েছি থাকতে।
তাহলে আপনার টেবিলে আছে।
হুম।
এটা সঙ্গে সঙ্গে দিলে পিকে বেঁধে থাকে, আমার আপনার জানেন।
আপনাকে বলছি যে এটা কিন্তু জিনিসটা আরো লিঙ্গার করলে কিন্তু গন্ডগোল হবে। আপনাকে তো যাই
Yes.
তা তো কোনো মানেই হবে না। যদি এটা পড়ে তাহলে একটাই বক্তব্য রাখতে পারে, কারণ তাহলে গন্ডগোল হবে জিনিসটা।
আমি কি করে করবো? আমার পক্ষে তো ডিপার্টমেন্ট থেকে দিয়ে গেল পার্টনার।
আরে সেটা তো আমি বুঝতে পেরেছি, কিন্তু কি করা যাবে সেটা তো আপনি আপনি একবার বলে দেখুন সেটা যে এই গন্ডগোল হয়েছে। তা আমি তোমাকে ফিরছে আমি ভেবেছিলাম গাড়িতে আছে, কিন্তু আমি গাড়ি থেকে পাঠিয়ে দিচ্ছি যে বেকার সময় নষ্ট আরো করে আরো সময় নষ্ট করে না। আমাদের তো ওইটা দেখাতেই হবে, তা না কালকে দিন সময় কালকেই
The expression common cause of action has been used.
Yes.
Where?
মানে rule 5 small a
Please read.
মানে notwithstanding anything contained in sub rule 1 and 5 to the tribunal may permit more than one person to join together and file a single application if it is satisfied, having regard to the cause of action and the nature of the disease proved for that may have a common interest in the matter. An association representing a person is not necessary.
Is the expression common cause of action used?
Common interest.
Therefore,
Common interest.
common interest, not
Common
a
interest.
common cause of action.
Right.
Not a common cause of action.
Is a common interest.
Common interest. Now, does it make any difference whether there is common cause of action and whether there is
Right.
common interest?
Cause of action is a bundle of facts.
So the bundle of facts is not the same, need not be the same.
Same.
It is not required to be the same. Only the interest is required to be the same.
Yes.
Interest
It is a common
means
interest.
common interest means the relief.
Relief. Mana kindly see the relief rate for that is at page 40. May I permit to press the relief short for paragraph 8. In view of the facts and circumstances of the application for following relief and mandatory order directing the depository department government of West Bengal Respondent 3 to extend influence giving effect to the memo dated 28 July 2005 and also directing the super engineer MCC Shivdi Room respondent to restrain himself from implementing the order of the depository as mentioned above and to furnish withdraw all communication made in terms of the government order with the applicants of the inspection order withdrawing the benefits under the CA scheme and recovers payment of made under CA scheme to the applicants. Order directing the responsibility concerned as per order of the court and the order of the government of West Bengal as per rules of the matter dealing with the benefit scale. Now, whether the tribunal has got any jurisdiction to implement the order. High Court has got power, but tribunal cannot say no because it is a subordinate authority. An order directing the respondent want to call to allow the petitioner to continue their enjoyment of current pay scale of their age scale benefits and benefits under the CA scheme and to restrain themselves from disturbing the applicants in the matter of enjoyment of future service benefits, including pensionary benefits. Order directing the respondent to certify it is not necessary. Third is to pay a salary.
Why you are referring to order 9 rule 13?
Now, order 22, rule 3. So, wait. It's সবই আমাদের। May I permit to read? Procedure in case of death of one of the several plaintiffs or the sole plaintiff, where one, two, or more plaintiffs dies and right to sue does not survive, to the surviving plaintiff or the plaintiffs alone on sole plaintiff or the sole surviving plaintiff dies and right to sue survives, the court on application made in this behalf shall cause the legal representative of the deceased plaintiff to be made party and shall proceed with the suit. Where within the time limit by the law, no applicant is made under sub-rule 1. The suit shall be abated so far as the deceased plaintiff is concerned. And on the date of the application, the defendant, the court may award him such costs may have incurred defending the suit or to recover from the estate of debtor. Now here is a rule 3.1. Why?
How 3 will apply? 3 will apply when the right to sue does not survive
No,
for the other.
Peer Lordship will can see. The verification made by the applicant number 1, as soon as he died.
The right to
No, he dies to
the right to sue dies
no, right to sue does not right. If he file an application for substitution,
unless the right to sue dies. How order 22 rule 3 will apply?
Applicant number 1 died during the pendency of the proceedings.
All right.
But when he died, if there is no application for substitution or certificate amendment, he has withdrawn.
Yes.
Withdrawn, that means accepted.
Only for him, not for the other applicant.
Can you see the language used?
Yes. You read, we are looking at it, where one or
two more plaintiffs dies and right to sue does not survive.
Right to sue does not survive is a precondition
Yes.
for this provision to apply.
Yes.
The right to sue of applicant number 1 will not be frustrated by death of applicant number 2 or vice versa.
No,
Therefore, order 22 rule 3, whether it will have any application, that we are asking.
No, order 22, whether application for substitution has to be filed, why they have filed?
That is a different issue. When you are referring to order 22 rule 3, the requirement is that the right to sue should not survive.
Survive.
How can you say that the right to sue does not survive?
That's why that language used by the tribunal, August 2022.
Forget about what the tribunal is saying. We are asking you how order 22 rule 3 will apply.
No.
When the right to sue is individual, when there is no common cause of action, then how one's cause of action can be?
Yes, I'm accepting the Mallard's view. Then Mallard, whether relief can be granted to the legal heirs of the petitioner number
applicant number 1.
1.
That you have said, but you are saying no, the applicant number 2's claim will also be barred.
Because the verification is made by whom?
So that is the only reason.
Oh yeah.
Because verification was made by him, therefore.
Yes. Then Mallard, on this date, Mallard, I have placed before your lordship, industrial tribunal, there was no application for substitution. The Supreme Court interpreted, if there is a right to survive, then application for substitution filed. In a other case, if the person concerned dies, if the right to survives, then it can be substituted. Now, the question is, after
Yes, please.
After El Chandra Kumar judgments,
Yes.
the tribunal exercising the power which was exercised by the High Court under Article 226, 227, then practically they have not been given the constitutional power, but which was exercised by the High Court under Article 227, 226, that power to be exercised by the tribunal. And when an application for substitution was filed with some delay, when their matter went up to the Supreme Court, then Malad Justice NP Singh, City Justice Venkataswamy, 1996 2 SCC page 205.
96 to SCC.
Yes, page 205. In applicability of
Yes.
Procedure B, head note B. Personal action where after the death of the person cause of action does not survive, the action also does not survive. But the other suits where after the death of the person does not survive, it does not suit. Order 22 therefore requires substitution for legal such case. Main question on the death of the party such case thus whether the right to survive not have. A personal paragraph 4. A personal action dies with the death of the person on the maximum actio personal materials come persona, but this operates only limited place of actions ex libris, such as the damage or defamation, assault or other personal injuries not causing death of the party. And in the other actions where the death of the party granting the relief would be negatory. But there are other cases where the right to survive despite of the death of against whom the proceedings have been initiated and such right continues the legal representative for the deceased, who is a party to the proceeding. Order 22 deals with the respect of the matter. Rule 1 of the Order 22 says that death of the plaintiff or the defendant shall not cause the suit to abate if the right to survive. That is why whenever a party should die, the first question whether is to be decided whether right to survive or not. If the right to be decided on personal right, which is extinguished with the death of the person concerned, does not devolve on the legal representative of the successor. Again, the suit, such suit, therefore, will be continued. Can't see the language. But
Order 22, Rule 3,
has been explained.
will it apply to a writ proceeding?
No, but writ proceedings have been applied.
Huh?
In a writ proceedings have been applied.
In this judgment?
Division in this judgment.
This judgment, if I remember correctly, it says that there is no automatic abatement of a proceeding under Article 226.
Yes, that's what I said.
Under the entire premise or the foundation of Order 22, Rule 3 is automatic abatement of a suit upon death if a steps not taken within 90 days.
Yeah.
In Article 226, the Apex Court in this judgment held there is no automatic abatement of the proceedings. Therefore, it has clearly held that Order 22, Rule 3 will not apply. But it has said that yes.
But can you see paragraph 10?
Huh?
Paragraph 10.
No, this court, in this judgment, it has held, it must be there, that there is no automatic abatement of the writ proceedings as contemplated under CPC.
Their lordship deals with the Punjab High Court rules, Rule 32, and our rule is Rule 53. In a writ proceedings, civil procedure could apply immediately as far as applicable.
As far as applicable.
Applicable. Then, same thing.
In your rules, which rule?
Rule 53.
Of the appellate side rules.
Rules. Hey, appellate side rules are what in here? Paragraph 12, the answer has been given.
12.
10, 11, and 12. As such, even it held that Order 22 is not applicable to the writ proceedings or writ appeal. It does not mean that the petitioner, the applicant in such writ proceedings or writ appeal can ignore the death of the respondent if the right to pursue immediately even after the death of the respondent survives. after the death of the respondent, is incumbent on the part of the petitioner or the applicant to substitute the heirs of such respondent with a reasonable time. No limitation. Act. For that purpose, doing so, what should be the reasonable time? The High Court may take note of the period prescribed under Article 120 of the Limitation Act for substituting the heirs of the deceased dependent of the respondent. However, there is no question of automatic amendment to the procedure. Even if an application is filed beyond 90 days of such respondent, the court take into consideration the fact that a particular place for the purpose of condoning the delay.
There is no question of automatic abatement. You have just now read.
ওরে তো withdraw করে নিয়ে
But he has filed the application for certain share amendment and withdraw the application.
That we have seen, he has withdrawn, but not he has withdrawn retaining his liberty.
Liberty, but liberty has to be exercised.
So therefore, that does not change the situation. He has not given up his right
No,
to
no, hold on.
substitution.
He shall have to apply.
In that order, he said that, just see what he has said when he has withdrawn.
In view of the above, both the MAs are dismissed as withdrawn, that therefore the applicants are liberty to take appropriate steps.
Correct.
Correct.
With liberty, he has withdrawn.
But he hasn't filed an application.
He has not accepted abatement of his claim.
Yes. But he has to file an application.
Of course, is required to be done. We are
this judgment
so
benefit cannot be
then
done. In this
what
judgment the
the
benefit
position that emerges is there is no automatic abatement. His right to file a substitution has been recognized by the tribunal
Yes.
by order which was not challenged by you.
No, no, why shall I? It is,
So therefore,
we have taken the point. That's why they withdraw the application.
he was not required to file a application for condonation.
Yes, he filed application.
I have retained my liberty. I withdraw this application. You also don't object to such withdrawal with liberty. You have not objected.
No.
In the two orders thereafter, a consent order is passed.
Yes, but I can't see the consent, whether it is a consent or not.
Whether it is a consent
Right or not?
Yes.
May I permit you to see the language? Internal page 3, middle portion.
Yes.
Mr. Ghosh appearing on behalf of the state submits that the matter is already settled by a matter of order of the tribunal way number.
Now what more consent is required?
Just the present application is also similarly situated as the applicant number.
What more consent?
Therefore, an order directing the respondent to pass a reason order in the light of the order will be appropriate.
What more consent there can?
No, not consent, but a consent on the consent. May I permit you to place the judgment of the Supreme Court on consent?
But just before that, can we see Rule 53? It is in which chapter?
Can you see the rule 26, 226, the rule is there, framed under Article 225?
appellate side.
I will not say got it. Rule 53. আমি কত কষ্ট করে পড়াশোনা করে রেডি করে হতে হয়েছে আমি সব নোট করেছি করে আমার মনে করে
না না
পড়েছি
আগের দিন বেরোবেন আমাকে তাহলে সেইগুলো পড়ে পড়েছি অ্যাটলিস্ট আমরা এতক্ষণ দাঁড়িয়ে
Rule 53.
রুল 53 ওটা না 35 ডেজ নাকি
মানে
আপনার স্যার রুলস কর
It is just a reiteration of the general law.
No,
as far as applicable, as far as possible, CPC may be applied, but this will not affect the inherent power under Article 226. So it is not. It is just a provision recognizing their inherent power under Article 226. It does not place you on any different pedestal from the other high courts. Shall be followed as far
as practical
as it can be made applicable in all proceedings, and it is with and nothing in these rules shall be limit otherwise affect the inherent power of the court to make orders under Article 226.
Madam, can you see
Therefore,
section 141 expression of CP procedure code?
of CPC.
141, section 141. What stuff? Hmm? Have you lordship got it?
Yes.
Miscellaneous proceeding. The procedure provided in the code in regard to the suit shall be followed as far as it can be applied in all proceedings, any court or civil division. In this section, the expression proceedings include proceedings under Order 9, but does not include any proceedings under Article 2.
Yeah. So therefore, this has been recognized, and rightly your rule cannot go above the CPC.
No, that's why
Therefore, the rule says as far as applicable as it may be applied, but then saving of the inherent power. So the explanation remains intact.
yes, expression that has been dealt with by a full bench. Our High Court AR 99 Calcutta page 29, voluminous judgment.
Explanation is not altered.
It has not been altered. But civil procedure code does not apply to the writ proceedings, but principles to be followed because how the application for substitution has to file.
For removal of difficulties, you will rely upon it as far as it may be made applicable. Because where there is no procedure, then what you will do? That is the best way to do it for maintaining uniformity. But will that determine the right of the person when the apex court has in unequivocal terms held that there is no automatic abatement?
Yes.
Question of automatic abatement.
Question, but then if can a degree be passed against a dead person?
All right. It's not a decree.
Sorry, order. Passed any order, degree or order.
It is not passed, it is not a decree, and it is not passed against any dead person.
No, but he has been granted relief.
It is not against a dead person.
In favor. In his legal year, in favor of a legal year.
It's not against.
No.
Against forever.
Oh, sorry. Can you excuse me, Manad?
Yes.
Can you excuse me, Manad, because I have committing some mistake today from the morning.
Yes. All right, we have understood. Your submission, we have understood.
তখন না তাহলে ওখানে লিবার্টিটা দেয়া আছে, তাহলে অ্যাটলিস্ট এই লিবার্টির জন্য ওকে একটা ফ্রেশ প্রসিডিং করতে হবে, এই প্রসিডিং এও ইয়ে পাবে না, সেটা পারতাম।
For the purpose of the liberty given by the tribunal, he could have filed a one-page application.
This
You are
rectification
citing
that should
some
be settled.
judgment on admission.
Yes.
You have not shown that.
না,
Deny.
আপনি তো ওইখানে রাখলেন।
No.
এইটা নাকি
98. 1996. Okay, dimension. Yes. 98 to SSC page 523. Justice J.S. Verma, Justice Kripal, and Justice V.N. Khare. Paragraph 6. Although if there is a concession what extent? To be considered in accordance with law. Nothing more. Consideration.
No, sir. The state council appearing there says that this matter is settled. This matter. He says this matter is already settled.
No, I'm
Please read.
Therefore, an order directly responded
Mr. Ghosh appearing for
the state submits that this matter is already
this matter is already settled.
settled.
This matter is already settled
But it is a
by an order of the tribunal. So that tribunal's order covers this matter. And then the next line.
Yes.
The present applicant is also similarly situated as the applicant of so and so. Now everything has been admitted, and then he says, ask the authority to pass an order.
No, but if there was consent
Yes.
on proposition of law, consent, consideration means consideration in accordance with law.
This matter is settled, petitioner is covered. Both concession is in specific terms.
Whether that legal point Not factual aspect. Legal pointing binding upon paragraph 7 mana kanisi.
Huh?
Paragraph 7.
Para 7,
Hmm.
para 6, you were just now saying.
Sorry. Total আছে তো? বার কর তো ওটা?
হুম।
পেয়েছিস?
আপনি পাঠিয়েছিলেন তো
হ্যাঁ,
কাকে?
হ্যাঁ। ইউপি নাকি বার কর?
পেজ 8 টা
হুম, হুম।
So if you are relying on paragraph 6,
হুম।
very well.
But we have no quarrel with the proposition of law that if any consent is given by a learned advocate of the state or a question of law or a consideration means consideration in accordance with law. But entire relief has been granted. Can you see? Now this finding is accepted by the Supreme Court. Then nobody will apply for substitution before the tribunal because no amendment takes place. But could you?
পেজ কত বললেন?
We did 98 to
পেজ কত?
এক সেকেন্ড দাঁড়াও। এটা গতকাল
পেজ কত?
আরে মনে করতে পারছি না।
এখানে তো রেফার করলেন নাকি?
হ্যাঁ। দু হাজার 1906
Yes.
On a currency that language, the respondent expert duty petition, the legal year should submit a representation shall be taken concern respondent to. If any amount has been directed to pay, the same amount shall be refunded within a period of 3 months. If the respondent has expired during the petition period, legal submitted detailed representation shall be taken concern and submitted to the respondent.
You are relying on para 6.
Yes.
We hope that we know that you have read entire para 6.
No. Facts are different. Factually different. But proposition of law,
Regarding proposition only we are saying, we are not saying about the
Fact.
facts.
proposition.
We are only on the proposition, we are not on the facts. When the concession is not binding, then
In which case, this concession should be binding and which case not binding upon the
no, but you say it is not binding. Your case is, in this case, it is not binding.
binding and the judgment which has been considered, his case could be considered. If that was order passed, we have no.
All objection is on the premise that the concession is not binding.
Yes. And one, there is no substitution. In a dead person, relief has been granted.
Please read the entire para 6. Please read the entire para 6.
In the direct
না
respondent.
না, প্যারা 6 of the judgment.
Oh, sorry.
The judgment চলে গেছে।
Okay. 1998 to SSC page 523. We have no doubt that the concession on this point being one of the law, it cannot be bind the state and therefore open to the state to withdraw it and done by a review petition before the High Court. It's a relief. Paragraph 6.
Therefore, it was open.
Open. only before the High Court. If tribunal passed an order,
Here the concession was before the High Court.
yes,
So it could have been withdrawn by filing a review before the High Court.
High Court.
Here the concession is before the tribunal.
Huh.
So it is to be withdrawn by the High Court, in the High Court.
No, I'm not saying that. But the
We are
concession,
saying that, even if concession is not binding, the judgment that you are relying upon says that if the government feels that the concession was not binding, there was a way of doing it. Have you done it this way?
yes, but whatever says, I have read that. But only my lord submitting. But if the order was passed, consider this case or file an application. But if
So if the tribunal had directed them to file the application before the authority, you would have no grievance.
no, but department will consider. Because order is passed in favor of a dead person. That's nothing more.
So consideration, if they would have directed to consider the dead person's case, then there would be no grievance.
No, but how that could be? First application for substitution or addition of party agreement to be allowed, then relief could be granted.
That you have said.
Pursuant to the liberty.
Pursuant to the liberty.
The liberty নিয়েছে।
Because currently she page 85, liberty has, they have obtained a liberty. They have not used a liberty.
Liberty.
The tribunal granted. Page 85.
Oh yes, we have just read that.
Yes.
That liberty to
If minor firm exercise the liberty, we have no objection.
in this.
But not in this application.
They have to do it there. But you don't have to withdraw your consent there. You have
No,
to
when,
raise that issue here.
Now, when they will file an application, then our right will come. Because according to our understanding, as soon as applicant number one died, everything goes.
That you have said.
Hmm.
And applicant 2, you say because the verification is no longer there.
Verification, the verification is there.
Yes. Why you are representing both the applicants?
পরের বার থেকে পাঠাতে
হ্যাঁ
আপনি বলে দেবেন তার জন্য আছে আমি
আরে
check করে নিয়ে আসবো।
3টে করে কপি করছে
এটা যদি না হয়,
So who has been impleaded here in place of applicant number 1?
But we cannot file a
না, না,
petition
কেউ-
against a
কেউ
dead person.
impleted হয়নি
Uh,
কেউ impleted হয়নি
Nobody has impleted.
You have not impleaded applicant number 1.
Legal errors have been impleted. Otherwise, application will be thrown out. We cannot implead a dead person as a respondent. Then we ascertain who are the legal errors.
What is certain? They had the knowledge of it.
Now, how can I say?
It was there.
There, because you have filed an application, but they have filed an application for.
Asked him a question, he is responding. You please don't interject. Yes.
When my lord friend clients file an application for substitution setting amendment, from that application we came to know that such and such persons were the legal representative of the applicant number 1. That's why we have made them party as a respondent, because under Article 226 writ petitions or in the civil procedure code, no dead person can. Kindly see. Wife, son and son. 2 sons and wife. Because our application will not be entertained by the High Court. If we file an application deleting his name, then the certified copy his name is there. No writ petition can be filed against the dead persons.
You have said anything in your writ petition why
Yes.
you have impleaded them?
Yes.
না না সেটা বলেছে বলে আমার অ্যাকচুয়ালি ওখানে দেয়নি ওখানে ওরা ইয়ে করছে
কোথায়?
ওই ফাইল থেকে ফাইল করতে পারলো না তখন এসে আবার ওটা চেঞ্জ করে
কোথায় লিখি?
তাতে না ওটা ডাইরেক্ট লেখা হয় ডাইরেক্ট লেখা হয় ডাইরেক্ট লেখা হয়নি ডাইরেক্ট লেখা হয় লেখা হয়নি এটা। ডাইরেক্ট লেখা। ওই যেটা হয়নি সেটা নিয়ে লক্ষ্য করে না এখানে ওরা বললো যে এটা ছাড়া হবে না। তা সেটা আবার লেখা 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 হয় না দিলে অ্যাপ্লিকেশন হবে না, তাই জন্য দিনের পরে আমার মাথায় আছে। এই জন্য ওটা complete হয়ে গেছে।
In the certified copy, 85, Pashukinath Devnath and other sources state was found. We cannot change the cost charter.
He asked you whether you have said anything, why you have impeded his legal heirs. You have not said it.
Because when the department refused to accept the dead person, then we take instructions for the legal, their name was supplied from the records, we have substituted.
Where have you said this?
No, we have not pleaded.
I have not pleaded.
Because the computer section initially refused to accept because of a dead person.
That's all.
Yes, yes.
First thing about you, can you look into the order? Order itself, order include that we can challenge by the state to not. The order itself speaks of only one applicant.
Of only one applicant. The last paragraph says for the other also.
That is there. That is there.
But it is an order for in favor of both the applicants.
Therefore, yes, that the court has ultimate finding in that. But the learned advocate, therefore, Mr. Banerjee submits that the applicant in his present application is also similarly circumstances, whatever it is. So the court, the entire order speaks of only one applicant. But second page of the order, Mr. Banerjee appearing on behalf of the applicant submits that. So it's not that my learned friend, what my learned friend's submission that the learned advocate lastly appeared on behalf of both the applicants. It's not that. After the death and after the substitutions, applications, and the being withdrawn, the learned advocate appeared before the learned tribunal on behalf of only one applicant. And second thing I will submit to your lordship that after the death of the applicant number one, it's the applicant number two that he has filed his rejoinder.
Who has filed?
Applicant number two. Kindly have a look into it.
Thank you.
What is this?
This is the rejoinder. Well, this
Not required. Whatever is not on the
has filed.
Yes. That you have shown from the order that the council was proceeding only in support of the claim made by applicant number one.
Yes.
He has placed the case only in support of the claim made by applicant number one. The court has considered the concession only on behalf of applicant number one. But in the end, the court has given direction that you consider for two. on its own the court has given. That is what you are saying.
And my lord, what as per my learned friend's submission, your lordship, that applicant number 2 was nowhere in the petition, at least at the verification, the page of verification. But my lord, the application, the tribunal application, it contains not only the page, the verification page. The entire petitions, both the applicant's signature is required. And if not that, then the power, the Vakalatnama contains signature of both the parties, both the applicants. That is existing.
So application, there is an initial of both the applicants.
Yes, Vakalatnama is there.
You said on every page, both applicants have put their
My lord,
signature.
না না একটা একজন দেখ
In fact, it is signed on every page by applicant number 1 only.
it was under authority. It was the power was given to him, consent was given. So, behalf of the applicant number 2, applicant number 1 wanted to put his signature. But the Vakalatnama is bearing the signature of both the parties.
Yes.
And my lord, with regard to your lordship, that substitution, but the fact I cannot see is there. The applicant number 2 initially had no information about the death of applicant number 1 and the years of applicant number 1, they did not have any knowledge of the pending application. So and as soon as they coming to learn about the pending application, and they appeared an application being filed, but unfortunately, your lordship, that application was withdrawn. But and subsequently, your lordship, the order that being passed on consent, lordship, as my learned said, has relied upon provisions of CTC. But I will be also tempted to rely on order 12/6. Order 12/6
Yes.
of CTC. This is before.
With order 12, rule 6.
consent order. Consent order.
The judgment on admission. The admissions of fact have been made either in the pleading or otherwise, whether orally or in writing. The court may at any stage of the suit, either on the application of any party or on its own motion, and without waiting for the interpretation of any other questions between the parties, make such order or give such judgment as it may think fit, having regard to such admissions.
The judgment on admission. Summary judgment. Summary suit. Not in ordinary suit.
But after this, my lord, the state, what is there, your lordship has been through the judgment, the order been passed, submissions that we made on behalf of the state advocate before the learned tribunal. The tribunal, what I humbly submit for lordship, the tribunal did very wrong in making the order that we passed.
Yes.
This much, so much.
That's all.
May I permit you go 1 minute?
Yes.
When order 12, the judgment on admission, not in other suit. Just money claim, money suit. Not in other suits.
Correct.
Judgment on admissions, just money suit. 30 lakhs or 40 lakhs.
Only for money suit.
Only for money suit, money claim or judgment.
Just one judgment.
But can you see that a party to the suit may give a notice pleading, otherwise writing that he admits the truth of all or any of the case, any other party. Notice to admit documents. Then, my lord, if every document which party is called upon to not
Was
to admit
one
it.
judgment that order 12 rule 6 applies only for money claim.
No, judgment on admission.
Ah,
Normally we find when there are certain cases judgment on admission in our original side or in a lower court, but not in other suits.
in every suit.
Now, if there is a
can be-
judgment on admission, the principle will be applied.
Every suit, if there is admission, then judgment can be passed on admission.
Admission.
So if there is a admission, it can be passed on admission. It is not specified for a particular kind of suits only
No.
that
It's a summary trial.
It doesn't say so. It says once there is admission, judgment can be passed on admission.
Admission, on
After
admission.
settling of issues also, it can be
Yes.
passed on admission. After the entire evidence also, it can be passed on admission. Why not?
Yes,
Where is the question of summary suit? Admission, if there is a clear and explicit admission,
yes,
then order 12 rule 6 will apply.
yes.
Yes.
And form of admission, rule 5.
Hmm?
Form of appendix C,
Clear and unequivocal, there is.
Yes.
rule 5.
Yes.
Form of admissions. A notice to admit facts shall be in form 10. In appendix C, admission of facts shall be form 12. Appendix A, the advisor has a mail clear. Hmm.
Even admission
Hmm.
cannot create a right for the one.
That's all.
That cannot create a
What?
jurisdiction.
That's all. Let's take down.
Can we make? Second time.
It's not from this case.
আমার ওই জাজমেন্টটা
It's in the earlier case.
কত আছে?
I'm sorry to disturb your losses, but for a long time, when such a short matter. When I got the come on.
Next,
Yes.
we have taken note of your
Oh.
submissions so that we don't forget.
Oh, sorry.
Item number 4.
Yes,
Your Lordship, it had fallen from your Lordship. This matter pertains to that the ex-employee had expired in 1993 and retired in 1978. The pension scheme, whether he'll be governed by the contributory pension scheme or the pension scheme that was going on. So meantime, he was suspended and he was reinstated. So your Lordship had asked for the relevant dates. I have prepared a short list of dates, your Lordship. And the second page is an elaborate date is when the scheme was applicable and from what dates the 12 times the scheme was option was given to the employees to avail that option. Judicial member.
given him a copy.
Your Lordship, the relevant circular, master circular is at page 17, which of the WPCT, your Lordship. Page 18 is the dates when the scheme was extended 12 times. The same has been incorporated in the list of dates, your Lordship.
There is the memo number dated 28/12/16.
That my lord is not with this application. That was with the OS had expressed. That has not been.
That we have asked on the last day, again we are asking today. Where is this? The second prayer is for quashing of 28/12/16. Where is this? We asked you on the last day also.
कितने पेज पे? पेज 28 पे था ना ये?
It's a
Page 17. कितना पेज पे है? Page 47, your lordship. Of the annexures I had handed over separately, your lordship, after paginating. The annexures were. और other side का copy क्या तुम्हें नहीं है?
The brief facts, we don't remember.
Your lordship, the brief facts is that the employee was placed under suspension in 1953. Disciplinary proceedings were initiated against him 1954. He was removed from services in 1957. And this pension, railway pension scheme was introduced with effect from 1st of April 1957.
Was removed when?
25th July 1957. 57, your lordship.
Was removed.
Your lordship.
Then what happened?
And he was reinstated on 21st August 1974.
And in between the pension scheme came.
Pension scheme came. The pension scheme was introduced on 16th November 1957 with effect from 1st April 1957. And the last date initially was 30th of September 1959.
From?
With effect from 1st April 1957. For that purpose, page 17, Master Circular is relevant, your lordship. Page 18 gives all the dates. 12 times the scheme was, the option was given to the existing employees and retired employees. And even to the
After his reinstatement, the pension scheme which had come into force on 16/11/57, it was still in vogue.
Your lordship, it was still in vogue. The last time in 1987 was the 12th time that the option could be availed, your lordship. Page 18 gives that chart, your lordship.
So you have repeatedly been asking for the options.
Your lordship.
But the scheme remains uninterrupted throughout this period.
Your lordship.
Till the date he was reinstated.
Your lordship.
After his reinstatement, did he give any option?
No, he did not. And thereafter he expired on 24th March 1993.
Till his death, he never made.
He never applied, your lordship.
If he didn't apply, then what was he getting otherwise?
Your lordship, they had the option of getting pension and he has got all the benefits under that. And we had also, your lordship, at page 19, the circular says that even family members who had expired, we had given them the option that they could refund the money and take the new option of the railway pension scheme. That was not availed by him.
That was not availed by him, but what was he getting? That we want to know. He was not getting the pension under the railway pension scheme. What he got as a retirement benefit?
Your lordship, what he was getting was, your lordship,
option was invited 12 times.
The option that we were giving was pension scheme, but he continued in special contribution to Provident Fund scheme.
So CPF scheme.
Your lordship.
Provident Fund scheme.
Yes, sir.
And his daughter has filed this application after a efflux of 40 years, Your Lordship. 23 years after his death, 40 years from the date of his retirement.
What the tribunal has done?
The tribunal has condoned the detail. First plea we had taken that it is time barred, it cannot be entertained. The tribunal had condoned the detail, stating that in para 9, page 65 of our reply, we had categorically stated 40 years and about 25 years from his death, and it can't be condoned, but the same was condoned. And the tribunal in its order at page
Statement on 21/8/74 was not giving him retrospectivity or any benefit to the past service.
Your Lordship, he was reinstated with back wages, so that was paid. He had filed a suit. He got the money. We have paid those dues.
So all past benefits was given.
Your Lordship, all past due benefits. Page 5 or internal page 5 of the order, paragraph 4.2 records that he filed a money suit and he has in 1989 and he had got those benefits.
Father never raised any claim for pension whatsoever.
Never. And it's not even their case that they had raised it. It was raised after an efflux of 40 years, Your Lordship.
Gave rise to this claim. What was the immediate cause for them to raise such a claim? Just like that, they have there is something.
Your Lordship, they have pleaded that I'm an unmarried daughter and I should have been, as per Supreme Court's order, I should have been granted the same that is pleaded in the OA, Your Lordship. That is.
What gave you the all of a sudden?
I have page 14, my lord, kindly see this annex, sir. There is a memo dated.
Why did you wake up so late? You are asking.
No, my lord, I did not wake up so late. It was my case that I did not give the opportunity to apply for the option because I was under suspension. Thereafter, when
You were not under your father.
my father, I apologize. My father did not get the option. Thereafter, when he joined, thereafter also he did not get the opportunity because
For 20 years, he continued after his reinstatement. 19
no,
years.
he joined he was reinstated in 74. He retired in 78. Only 4 years, and that too, he was also under leave due to his.
When did he retire?
21st August 1974 and reinstated on 30th of September 1978.
Was reinstated on 21/8/74.
Your Lordship, 21st August 1974, reinstated, 30th September 1978, he retired.
He retired in 78. What is the date?
30th September 1970.
39.
39, 70.
30.
So he was there for around 4 years. In that 4 years, he
That
did not-
4 years he did not apply.
The last time the option was invited in which year?
Your Lordship, the last time it was 1985. Page 18 is 12 times it was given. 1987 was the last 30th of
Ninth
September.
option was given when he was reinstated, during his reinstatement.
Reinstatement, Your Lordship, seventh option was during reinstatement
The
1974.
ninth option, if we, from the list of events that you were given.
Your Lordship, eighth option, 1st of April 1973
Eighth option.
to 31st December 1978. The eighth option was also given,
That was available to him.
Your Lordship.
Before filing TOI, she had made any application to you?
Your Lordship,
Representations. Thereafter, that the improved memo, that is 2016, that was passed.
We have just seen that letter.
Your Lordship, we had replied to the same as well, page 31 of the annexures. 13th October 2015, we had categorically replied that after examining your representations, under reference, it has been revealed that your deceased father was not a pensionable staff, and you had also failed to adduce copy of pension pay order of your father. As such, at this stage, your presentation for resanction of your family pension cannot be entertained.
Is the representation also annexed?
Your Lordship, the representation is at page 32 of the annexures that has been given, Your Lordship.
It's 32, 34, my lord,
32 onwards.
32.
Well, let's say application.
लिमिटेशन पीरियड के अंदर है इसमें प्रीडिंग्स के
So far as the third of the priority concept, that is my legal guidelines sufficient as per my that is legal guidelines sufficient. Because my lord, if my lord kindly comes to the page 47 of that annexure, that is the issued memo. My lord, before passing of this memo, no opportunity of hearing was given. That is my lord, blatant violation of the principle of materials. Secondly, my lord, if my lord comes to that memo, so at this distance state, ignorance cannot be considered for giving option towards family pension. In view of the above, there is no scope of granting family pension beyond 25 years of the age to the unmarried daughter. My lord, kindly comes to page 48. This is the next page. My lord, paragraph 2.
Not only because you are 25 years.
I have more than 25 years. That is beyond 25 years that there is an option for that, for granting family pension to the unmarried daughter.
Not the point. That's not the only line in that order. Read the entire order.
The main part is that my father did not pray for any pensionary benefit.
Not only he did not pray for, he was not covered under the pension rule. He never got the benefit.
He did not get the opportunity. At that
Therefore,
relevant time of
a
period,
person who is not getting pension, whether his family can claim family pension, even if you are the only son and you are eligible, can you get it? Forget about 24 years or less or more than 20. A person who is not a pensioner, how can his legal heirs claim family pension? And that also 40 years after his death. And the tribunal has allowed it. Have you, in any of your application, did you say that he was a pensioner or that he ever applied for pension or he exercised his option?
no, my
You
lord,
filed so many representations. Has this fact been stated in any representation?
no, he did not get the opportunity. My lord. That is my case.
Because he was ill.
He was from 74 to 78. He was on leave because due to illness. Thereafter, in 93.
He was on medical leave.
Yes.
Have you said, let us see anywhere, have you said that he was on medical leave? Show from your representation.
Medical. Lordship, page 36, para 3 of his OA, he has stated that after retirement, he was bedridden.
I am not said.
But why? Why after so many years? How could you stake a claim knowing that your father was not a pensioner? What ground the tribunal has allowed? Which judgment of the apex court? You have relied on which judgment? Tribunal says in view of judgment of the apex court. Which judgment?
Come page 40,
40
1/4 of the annex
of
and annexures. Paragraph 4. Page 16, that is the type copy.
office memorandum.
That is obviously, here it is referred that the Honorable Supreme Court.
Page 16.
Page 16. There are four.
Lordship, page 18 of my writ petition, 11th option is this memorandum, Your Lordship. 18th of June 1985, which was till 17th of December 1985.
For family pension, this is for those, the wife of the pensioners. This is not for someone who was not getting a pension. You are not getting a pension.
They had to take that option, Your Lordship. Page 18, the chart that I have showed, this was last applicable till 1987. They could avail this option. This was the 11th option, Your Lordship.
It is the judgment of the Supreme Court which has been the basis of this office memorandum. Some judgment in civil appeal number 2225.
Lordship, I'll get a copy of the same. I do not.
Let us see, let us be sure.
Your Lordship.
Because the subject not only says grant of family pension to families of government employees who retired or died before 1/1/64, but it says or are otherwise not covered by the family pensions. So what does it, since it is a office memorandum issued in purported compliance of the judgment,
Your Lordship.
Better to see the judgment.
Your
what- why it has been. Go through the judgment.
Your Lordship.
I will try to get an.
Your judgment.
Course of argument.
From 16 to 23rd.
Your Lordship, a stay may be granted because they have filed a contempt before the or an undertaking by him will also suffice, Your Lordship.
The court, the counsel for the respondent submits that
Item number 5, item 5, my lord, on the last occasion, my lord, his lordship is directed us, my lord, to file a supplementary affidavit, my lord, disclosing, my lord, certain documents, my lord. So, my lord, may I file hand over a copy of this?
give him, then he will have to see.
Lordship. Two documents lordship has sought for, my lord, and the one notification, another one is, my lord, the application for compensation appointment. Both these document has been annexed, my lord. Lordship.
The state council submits that
Grateful, lordship.
the date, tell them the date.
কি আছে? Eh.
It's 21st.
But can it be on 21st? My junior has some lordship.
Great.
Lordship. Great.
Number 6.
Please, your lordship, in this matter, Chaturvedi will appear, my lord. Mr. Piyush Chaturvedi will appear in this matter, my lord. He is out of station, my lord, kindly adjourn for petitioner.
As stated, list after 2 weeks.
One week, man.
As stated, list after 2 weeks.
Ah.
Next.
2 weeks. This one.
Number 7.
Wait, please, your lordship. Lordship director on the last occasion to serve afresh, I have served.
They are represented.
This is UPSC, but there are two other parties. One is Andaman administration and the other one is the Union of India. Though Union of India is not
Why Andaman administration
Because-
being done here?
no, because matter was from Central Administrative Tribunal. So naturally, Central Administrative Tribunal has your lordships have jurisdiction.
Regarding what?
My lord, regularization. 30 years of service
Service of the Andaman administration.
under the Andaman administration.
Regularization of ad hoc happen. Regularization of ad hoc happen.
Whatever, but we are only on whether the issue of Andaman administration, why
No, because
there is a circuit bench.
no, circuit bench is there, but this order, main order was passed from Calcutta because circuit bench always does not function there. The main order is from Calcutta.
The OA was filed in the circuit bench and Andaman.
Let me see. Well, it's page 336. The order is there. It was,
It must have been filed in the circuit bench at Andaman.
yes, it should have been filed in the circuit bench ultimately because the circuit bench does not always sit. Therefore, the bench over here takes up the matters. That's what happened here also.
Because it is the same presiding officer.
Yes.
But that will not make it amenable to this High Court here.
Yes, yes. My lord, we are doing it regularly on that basis.
The order will remain an order of the circuit bench of the Calcutta.
No, my lord. It's Kolkata bench, Lord.
Calcutta.
Huh?
He is passed in Calcutta. Honorable member passed in Calcutta, sitting in Calcutta.
That's why, my lord, the heading is Central Administrative Tribunal, Kolkata bench, Kolkata.
A copy of the OA.
And my lord, EPT, well, it will be within brackets, Harpi, that court.
No, জিজ্ঞেস করছি আমি।
Which page? OA?
My lord, let me check. My lord, the rejoinder is filed in Calcutta. The Kolkata bench, Kolkata. Rejoinder is at page 318, my lord. OA is also there.
Yes, 24.
24.
24. but the whole matter was heard in Calcutta and order was conducted. It never goes to such.
Sometimes that is,
That is a practice. Then what is the point in having a circuit bench?
oh, because my lord, recently, my lord, recently, because few years back, this is a 2019 matter. Few years back, the circuit was not going regularly. They were having difficulty. That is why they were doing it from here itself. But now the circuit has been extended. It is going there on a regular basis. আচ্ছা, সেটা তো আমি জানি না। So this matter was heard here, it's filed here, heard here, everything was done.
Your regularization has been turned down.
Yes, regularization has been turned down. Though Andaman administration was supporting me continuously. And in similar matters, my lord, up to Supreme Court, we have won. I have brought those judgments because Andaman was having geographical difficulties. But as a result, they were appointing on ad hoc basis. Selection process, if taken, undertaken also, my lord, no one used to want to go to Andaman those days. As a result, and she's joined the service in 1994. But my lord, Andaman administration I have served. I don't know why they are not here today. I have served. And they are supporting me because it's only UPSC who is objecting. And UPSC, my lord, with great respect, my lord, in Supreme Court, we had taken a preliminary point that UPSC is an advisory body. It doesn't have a jurisdiction mandatory in nature in this regard. And when Andaman administration wants to give appointment, where is or regularize the services, where is the question of UPSC standing in the way? Andamane কি আছে?
I জানি কি আছে। But it is beyond the recruitment rules. That is why UPSC is objective. So recruitment is direct recruitment. There is no provision in the order that ad hoc service will be regularized. It is our objection, main objection.
He was on contract.
No, selection was initially on ad hoc basis. Lord, the selection was, Lordship will kindly come to. Page 65, my lord. Page 65. Andamanকে সার্ভ করলাম, Andamanকে সার্ভ করলাম, Andaman representation.
The administration appear.
Unfortunately, I'll do this, my lord. I'm going to Andaman because of circuit going there. I'll try to impress upon them to send their,
Fix a date.
yes, my lord.
To 20 May. Let the land council for.
There is no direction for filing an affidavit. Commission
Lord, let the affidavit of service be kept ready.
instead of 70
নামটা দিচ্ছি, দিচ্ছি junior.
Whether they appear. Yes.
I'm great. বলুন বলুন বলুন।
Hello, I shall go to Chennai for details for my medical check. Take it on time. Take it on time.
All right, 90.
Time. Yes.
I'm great.
I Item number 8.
Met with your lordship. Madam for the petition. Malad,
Respondent is appearing.
Malad, these matters, Malad. Malad, this matter is one of the bunch of the matters which have been filed before this honorable. Other bunch of the matters, Malad, have been taken up by this honorable court, another honorable court in bench, which has been, Malad, posted after certain time. So, Malad, very crux of this matter, Malad, is, Malad,
Another bench is in session of.
no, not in season, Malad. Malad, this was taken up by the earlier, when the determination of the, yes, prior to this. So that, there,
There are more, 5 more or 4 more.
5 more. But,
Some orders have been passed in the earlier case.
yes, yes.
For exchange of pleadings.
But yes, not exchange of pleadings, because all pleadings are there already on record. So so that it could be hard out, not altogether the matters.
So let it go with that matter.
Malad, if I request your lordship, Malad, it's a very short point is involved. But if those matters, Malad, could be taken up together by this honorable court, Malad, it could be.
What is the issue? Just give us.
Yes. Malad, the issue is that, Malad,
You have not succeeded before the tribunal.
I did not. So, Malad, my prayer before the learned tribunal was that I wanted to have the pay parity with my learned juniors. So, the juniors.
Yes.
So, Malad, I wanted, Malad, pay parity with the juniors.
Yes.
So, Malad, what happens here, Malad, initially,
The disparity arose.
It arose, Malad. I was engaged in 94. The private respondent engaged in 97. I continued in Kolkata. In Kolkata, Malad, there were no post for junior accountant, which is my promotional post. My promotional post of junior accountant was bifurcated to somewhere else. But my junior, who was engaged in 1997, was engaged in Bombay. So in Mumbai, Malad, there was a post of junior accountant. So he got promoted in junior accountant before me. So Malad, thereafter, we both of us were, Malad, there in
remains common.
Seniority, Malad, yes. At that particular juncture, it was there, common. Then, Malad, what happens? He took the transfer from Bombay to Kolkata by Rule 38 of the Postal Manual. By taking the transfer, Rule 38 transfer, he came from Bombay to Kolkata and he accepted bottom seniority. So, thereafter, Malad, he was also reversed to the post of junior accountant. He was reversed in the post of junior accountant.
By then he had already acquired a higher pay. Therefore,
now he has been enjoying that. And now he is junior to me in the post of senior accountant also. Thereafter, being reversed in junior accountant, he was engaged in senior accountant after me. But even in spite of that, Malad, he
claiming stepping up.
Malad, I am claiming, Malad, parity of the pay. Because I am senior accountant before, from the date before he became senior accountant. So, Malad, I was also relying upon.
After coming here, he also became senior accountant.
Yes, subsequently. So I was also relying upon, Malad, this honorable court's decision, where the honorable court has been pleased to, Malad, direct that whatever was the previous situation, we will not mind. But presently, who are there in the same post, the seniors, they should be, Malad, given with the same pay with the juniors. That is the ratio in the judgment.
Same pay, not same pay scale.
Yes, Malad, same pay.
Without stepping up of scale, stepping up of pay without stepping up of scale.
So, Malad, the other matters, Malad, I am just handing up your lordship, Malad, the numbers.
All these persons are in the same department.
Same department.
They are all now claiming with reference to the same persons.
Not same person, series of persons.
No, all these 5 are claiming with reference to the same person who has come from Bombay because.
Yes, same, but they're same persons.
There are many who have come.
Bombay, Ahmedabad, different places.
No, but since there is a concept of one relinquishing his seniority and going to the bottom of seniority at the place of posting of his desired station, there is nothing that deals in the rules with the interstate determination of pay scale, how it is to be guided. There is no provision
Rule 38 says that he will be placed in the bottom seniority rather.
there, but regarding pay, there is nothing.
I did not find, subject to correction of my learned senior friends. I did not find. In the postal manual, at least. So, my lord, I will be providing your lordship, my lord, with the numbers. If all those matters, my lord, could be taken up together, subject to
This or you are appearing in all the cases.
all matters. My lord.
Can fix, give us a date.
So any day, subject to lordships.
If you agree. You give us a date. The moment we say date, let's say not this date. Therefore, it is better that you give us a date. Give us a date after 3 weeks or 4 weeks.
3 weeks বলছি না। যেন আমি বলছি। But would it be a lordship's pleasure, my lord, to post it on 25th of February?
As jointly
25th? মঙ্গলবার।
has to be looked into.
No, no, I removed that, my lord, misunderstanding. All these matters were taken up together in the learned tribunal. Common reply were used by them in that matter. So one reply is annexed.
What about annexing? We'll go by the records that was there before the tribunal. We don't need. There's nothing additional which needs to be.
দিয়ে দিচ্ছি, নাম্বারগুলো দিয়ে দিচ্ছি। Grateful.
If it is there in one file, then
Yes, one they have used in one matter, it is there, the principal matter. এটা? লেখ কাগজে লেখ।
Number 9.
My lord, in item number 9, my lord, Mr. Sukanta Chakraborty will appear, my lord. I'm playing for not today due to some.
in presence of learned counsel for the respondent, matter stands adjourned on prayer made by the for the day.
Number?
Item number 10.
Maybe also. The last occasion. এটা দিয়ে দিন তো। এই যে। But I'm for the petitioner. I tell you, পুরা হাজির হয়েছে।
What is
But last occasion, the learned advocate for the respondent, when submitted, they will file the opposition. But till today, have not yet filed any opposition. Which are filed in the order.
is out of station? Then what do you want?
Is paying for adjournment.
You have informed us that Mr. Bag is out of station. What do you want? We are asking.
আরে কি চাইছো বলো? আরে কি চাইছো?
We are intimated by, give your appearance by Mr. So-and-so.
No, you have to give that direction at a time. If you file, okay. Yes, sir. I get it. On a 1 week time, next Thursday. Obviously, next Thursday. I get it. Sir.
Item number 11.
11, I am for the petitioner. Here on 3rd December 2024, Lordship directed to file a learned counsel appearing for the Union of India submits that an affidavit in opposition shall be filed. I have not received the affidavit of service till now. Only paying for 1 week time.
The filed affidavit of service.
Yes, sir. ফেরত করে বলতে হবে।
You file it on the next day. None appears on behalf of the Union.
ওই নামটা আমার নাম।
Item number 12.
May please, Your Lordship.
Lordship, in this matter, Mr. Pratik Chandra Das is appearing on behalf of the respondent, Lordship.
We'll see if required, we'll ask him.
Lordship,
Union of India's appeal. Writ
yes,
petition.
this is a writ petition by the union again.
Because earlier it has been taken up.
It has been taken up and they would to file and they had raised the maintainability issue and had said they would file an affidavit in opposition, but that has not been done as yet.
Saying not today, not tomorrow, Lordship, as Lordship, one of the family member is seriously ill on. Lordship, kindly.
On personal grounds, a prayer has been made.
Next date, 14th February, deeply obliged. 14th.
Item number 13.
Item number. Item number 13, my lord, I am for the petitioner, my lord.
Yes.
In this matter, I am led by Mr. Ajay Kumar Chauhan, my lord. He is on leg, my lord. May I start, my?
There was a direction to intimate the respondents.
Yes, my lord, I have.
You are appearing.
That was a great, my lord.
There are private respondents. You are for the private respondents.
Yeah. No, I was, my lord. We were the applicants for the, oh, yes.
The Union of India has come in the.
Yes, my lord. Union of India has filed.
The judgment was, so to say, the final order.
Let us senior be here.
The final order was passed. It was passed on
11th November 2022.
22,
Where were you?
in 22. And most of the minor directions of the learned tribunal has already been implemented.
Complied. How many are remaining?
Department.
You said most are complied, so how many?
Only one, that a committee will have to be formed. And that for the purpose of framing of it, that was the direction. That the respondents will form a, Lordship kindly goes to page 18 of the. Page 18.
Also, the tribunal has barred their disengagement.
From 17 years.
The tribunal has barred your disengagement.
Lordship kindly goes to page 17 of the judgment. Starting from paragraph 18.
Single bench को बोलिए
If I don't need the branch, that was the division bench ना उन्होंने larger bench को
कौन सा
तो यहाँ पे bench
लार्जर में पेंडिंग है अभी
भी मतलब 26 नंबर को ब्रांच मैटर था वो डिसएग्री करते हैं वो उनके हिसाब से सिंगल बेंच में नॉट द मैटर सो ही इज रिफरिंग टू द लार्जेस्ट बेंच
क्या नहीं है सेटिस्फाइड नहीं वो तो बोलिए बात
ये नया बेंच का जिसमें पेपर
Right.
Directions have been given twice, once in paragraph 19 and then again in the last paragraph.
तो डॉक्टर कहाँ पे
Paragraph 19, the tribunal has given certain directions.
Paragraph 10, in fact, is at page 17 at the bottom. Paragraph 3. Then,
So this is in terms of another case.
this is paragraph 3 and simply restriction. Let it be. As to whether it can be absorbed or not.
91 without any interim orders against sanctioned posts, then what remains?
sanction post, my lord. Before going to the merits of the case, I would like to draw your, my lord, attention. Judgment passed without quorum. Kindly see, my lord. Yeah, only judicial member passed the order, my lord. And my lord, power of the tribunal could only be exercised by two members, one being the administrative member and another judicial member. Kindly see section 5 of the Administrative Tribunal Act.
Notification by the chairman.
At least, I think, as per my instruction notes, no,
Not a matter of instruction, it is a matter of fact
back.
which you can gather. For that, your client need not tell you. There is a provision that a notification can be issued.
Notification can be issued, my lord.
Have you said that there was no notification also issued?
At this moment,
Merely by relying on this, you will not, you cannot make out this point. There is a provision and the honorable member who has passed the order is a judicial member.
judicial member.
This is the allocation of business by the notification. Where is that fact?
Then my second submission, my lord. Petitioner did not challenge the speaking order.
Not challenged.
Not challenge, my lord. I am submitting, my lord. They are common applicants in 2 OA. Kindly see page 67.
What is that page
Page 67, applicant number 7.
Yes.
Uh,
The
Atindra Kumar De.
Applicant number 2 in the present proceeding.
Yes, my lord. In this OA, there was a direction to consider the representation. And the same was decided and rejected. Kindly see, my lord.
What is the date of disposal of representation?
I'm just 76. Page number 75, my lord. This is speaking order annexed by the respondent in the before the CAT, my lord. Relevant portion is, my lord, page 76, paragraph 2. Entire selection process to be conducted by the staff selection commission, my lord. Now we have no power.
Not been challenged.
Not challenged, my lord. Although they annexed the document.
The date of this order.
You are referring to which page?
Page 75. 25th March 2019.
Where do you have the date?
Double pagination.
17.
Which page?
79. Page 79.
Your paging is different.
Double pagination, I don't know.
Double pagination is
79. What they are supply. One other.
See.
one page at the corner.
सही है page.
879 we have 100 pages.
Some have three sequences. It is the second round of
Very difficult. To cut the wrong one and put the correction. So what we do in that case, I shall engage my lord again afresh. My lord has an experience. Over. But I would have raised the first question. That you are challenging a judgment or rather a final.
because the tribunal's order is not a draft. It is a final. A final order that was made on 11th of November 2020. You are affirming an affidavit in your application in 2020. Is there any single paragraph as to why this meeting?
Not expressed, my
Is
lord,
there any single paragraph?
and fairly submitting, my lord.
Well, if your lordship so desire, I can come up with an affidavit. The more the merrier. But a bit long time. Maybe a little longer.
In the meantime, my lord, proceeding being initiated, my lord. No content, my lord. Very well, my lord. Very well. अभी मुझे speaking order देखा है।
Item number 14.
My lord, in this matter, my lord, I am appearing through virtual mode, my lord. I am appearing on behalf of the respondent applicant, my lord.
Your Lordship, this is pertaining to the army pension, disability pension matter. Mr. Kundalia was arguing this matter. His legs before another court. Could it be taken up on any other day?
You are appearing for the respondent.
My lord, what my learned friend is submitting, my lord, it is not the same case as my learned friend mentioning in other matters, my lord. It is a case, my lord, for the movement of shifting from one room to another room, my lord. He got injured, my lord. It has been admitted. A severe injury is there, my lord. In the court of inquiry, it has been admitted, my lord. So what my learned friend is mentioning, the different matters, my lord, they are not in at all the same matters like my other matters, my lord.
The senior counsel is not available.
My lord, my humble submissions, if your lordship kindly fixed on Tuesday give some precedent over other matters, my lord, because I am suffering because lord, this is a question of my pension, my lord.
Today it cannot be. We can have it in the next week only. After that,
My lord, then Wednesday, my lord.
counsel for the petitioner submits that the senior counsel.